Welcome to the first video discussing the issue why forensic science is stagnant in Kerala. So before we dive into finding answers to this particular question, let's first examine whether forensic science is stagnant in Kerala or not. As we know, forensic evidences or scientific evidences often forms a backbone of criminal investigations and trials, especially in the absence of direct eyewitnesses. But what happens when there is a delay in obtaining these reports from forensic science laboratories to the courts? So let's analyze a recent and significant order from the Hon'ble High Court of Kerala in Sanjay Oron versus State of Kerala and others, dated 6th day of February 2024. In para 19 of this order, the Hon'ble High Court of Kerala observed that we have moved into 75th years of independence. It is common knowledge that investigation agencies now heavily depend on scientific evidence and technology for investigation of crimes. In these times, we cannot put our hands in the air and cry about the dearth of staff and lack of infrastructure. With the alarming and exponential increase in crimes in recent years, it is high time that we ensure the facilities for the dispensation of justice are put in place, especially when the entitlement of the accused to a speedy trial has been emphasized by the Honorable Supreme Court of India in Husainara Khatun versus State of Bihar to be implicit in the spectrum of Article 21 of the Constitution of India, that is right to life and personal liberty. If the scientific analysis is inordinately delayed, like in the present case, the accused may take it as a valuable defense, and the same will be detrimental to the larger public interest. So the para 19 highlights the importance of using scientific evidence and technology in crime investigation, especially considering an increasing number of crimes in the society. And the court also emphasized that excuses like staff shortage or lack of infrastructures are no longer acceptable in today's time because ensuring speedy trial is crucial as stated by the Supreme Court of India in Husainara Khatun versus State of Bihar. And delays in scientific analysis can harm the case as well as detrimental to the public interest. So here I want to emphasize the delays in obtaining forensic reports and how it affects the criminal justice system without going to the merits of this case. So in short, the facts of the case is that an FIR was registered against the accused under section 302 of IPC on 21/10/2019. Subsequently, accused was arrested and now he has been in judicial custody since 23/10/2019, which is now 4 years and 3 months. Yet the trial has not commenced. So the problem lies here. Even after spending 4 years and 3 months behind the bars as an under trial prisoner, the trial has not commenced. Therefore, the accused moved this bail application. When this matter came up for consideration before the Honorable High Court of Kerala had called a report from the additional session judge in this matter. So, pursuant to the direction, the learned session judge had reported that even though the case was committed to the court, reports and properties from forensic science laboratories were not received. Therefore, charge has not been framed. He also stated that since the prosecution has cited 39 witnesses, the court would at least take 6 months to dispose this matter. That too after receiving the reports and properties from forensic science laboratory. So based on the report filed by the learned session judge, High Court of Kerala directed the investigation officer to file an affidavit stating why the reports and properties from forensic science laboratories were not submitted to the court. Accordingly, investigation officer filed an affidavit stating that final report was submitted on 1/3/2020 and 10 material objects were forwarded to Forensic Science Laboratory Trivandrum on 28/10/2019. And he also reiterated that even though the case was committed to the court and numbered, the charge has not been framed for the want of scientific reports from the forensic science laboratories on material objects connected to this case. Also stated that earlier investigation officer had sent a reminder to the director of forensic science laboratory on 1/2/2023 to expedite the analysis, and he asserted that there is no laxes on his part. So considering the affidavit filed by the investigation officer, the Honorable High Court of Kerala suo motu implemented the Director of Forensic Science Laboratory as an additional respondent in this case and also directed him to file an affidavit stating the reason for inordinate delay in submitting the reports on the material objects which were reportedly sent him on 28/10/2019, which is more than 4 years and 3 months back. So, in response to the above order, the Director of Forensic Science Laboratory filed an affidavit stating that he received the material objects on 5/11/2019 in 10 packets. He also received a reminder from the Judicial First Class Magistrate on 9/8/2021 requesting urgent analysis. And he also stated that, however, the analysis got delayed due to the high volume of requisition received for getting reports on material objects in 3,549 cases in POCSO Act and from several fast track and other courts. Further, he stated that due to staff shortage, the laboratory was not in a position to urgently conduct a scientific analysis on the material objects connected to this case. So, in summary, the alleged murder took place on 21/10/2019. Subsequently, the accused got arrested and remanded to judicial custody on 23/10/2019. And 10 material objects were forwarded to Forensic Science Laboratory Trivandrum on 28/10/2019. And the judicial magistrate sent a reminder on 9/8/2021 to the Director of Forensic Science Laboratory. And also, the earlier investigation officer also sent a reminder to the Director of Forensic Science Laboratory on 1/2/2023 for urgent analysis. However, the analysis was at standstill for 4 years and 3 months. The Honorable High Court of Kerala strongly criticized the explanation provided by the Director of Forensic Science Laboratory in the paragraph 24 of this order, stating that in the above conspectus, the explanation put forth by the Director of Forensic Science Laboratory that the inordinate delay of 4 years was due to the massive influx of cases under the POCSO Act and the lack of staff is not appealing to this court as it does not align with the mandate of doctrine of speedy and fair trial proclaimed by the Honorable Supreme Court of India. Also, the Honorable High Court stated that right of speedy and fair trial to an accused is an integral part of Article 21 of the Constitution of India, that is, right to life and personal liberty. And it is the constitutional duty of the all organs of the state to ensure speedy justice. So, while concluding, it is evident from this case, as well as the admitted explanation given by the Director of Forensic Science Laboratory in the affidavit to the Honorable High Court of Kerala, that forensic science is stagnant in Kerala. There is a staff shortage, a lack of infrastructures throughout the forensic science laboratories in Kerala. Keeping a person in jail for more than 4 years without commencing the trial, that too due to the failure of forensic science laboratory providing the report on time, which poses a great threat to the criminal justice system, which is not only affecting the right of the accused but also detriment to the prosecution and also allowing the science to defeat justice. Do you think this is an isolated case? Never. There are a lot of under trial prisoners awaiting for the forensic reports throughout the jails in Kerala. So in next video, I'm going to analyze few important statistics regarding the crime rate in Kerala as well as the pending cases in forensic science laboratory in order to prove the fact that forensic science is stagnant in Kerala. Stay tuned.